Now I'd like to introduce Barbara Anthony. Barbara is the director of the Northeast region of the FTC and has had a long, I don't want to say long, has been involved in many areas of consumer protection as well. Both in the Massachusetts Attorney General's office as a top aide to the Attorney General, as Chief Compliance Officer at Baybanks, as Assistant Secretary of Consumer Affairs and Business Regulation in Massachusetts, and at the Justice Department in Washington, D.C. She's responsible for antitrust and consumer protection matters in New England, and also, interestingly, in Puerto Rico and U.S. Virgin Islands. I'm surprised you haven't put your office somewhere else other than New York City. She's done a tremendous amount of outreach in her time as the director. We've certainly seen a lot of work, in particular in predatory lending and privacy areas. And anyway, welcome. Thank you.
Thanks very much, Jeff, for inviting me to come tonight. It's a pleasure to be here with my colleagues. I guess I've been here now from Massachusetts for 2.5 years. I still go back and forth between Manhattan and the People's Republic of Cambridge. And I have to say that I really am thrilled to be in New York and to work with such terrific people as the folks we've had here on the stage, and with this committee and with the City Bar. It is a terrific consumer advocacy community. I will tell you that there's terrific advocates in Massachusetts too, but the numbers aren't there, and this is just for a lot of reasons. But this is really a terrific city for consumer advocacy, and I'm happy to be a part of it. In terms of preparing for tonight, in terms of predicting what are the big consumer issues beyond the year 2002, I thought about consulting a psychic to see if we could get a beat on what would unfold ahead of us. And so I called Miss Cleo. For those of you who may not be aware, Miss Cleo is a late-night psychic. Those of you who have insomnia or surfing for other things, we won't go into here, and who I think operates out of Florida. And the FTC sued Miss Cleo and her companies, and we sued her for violating the pay-per-call rule. This was a source of great confusion, I think, among consumers. We didn't sue her for not really being a psychic. We sued her because she violated the pay-per-call rule. You can't lie to people and then charge them $5 a minute for the telephone call to the tune of about $32 million. But this confusion among consumers still lasts. There was a letter from a consumer recently. They said the FTC got the whole thing all wrong. Number one, Miss Cleo is not a psychic. Number two, her monkeys are not really magic monkeys. And number three, she's not from the Bahamas, she's from the Bronx. So, we try as we may. But anyway, Miss Cleo's lawyer said that she really wasn't available to consult in terms of the major consumer issues. So I'm going to start flying on my own tonight. Let's say a couple of things, just picking up this theme that the Attorney General and the Commissioner have just mentioned, just briefly with respect to pharmaceuticals and predatory lending. And by the way, my comments are my own. I don't represent the views necessarily of any commissioner of the Federal Trade Commission, nor the Commission. But I do think that moving forward that there may be some action, if not in the immediate future, certainly in some time to come, on the pharmaceutical level with respect to the patent issue and prescription drugs. One of the things that the FTC has been involved with is suing brand name companies who end up in litigation against generics, paying off generics not to bring their drugs to market, to make it very simple explanation. One of the things we're finding now is that we have actually brought a number of these cases successfully. States and private litigants have followed up with class action suits, and you can imagine. But the next iteration now is something called, what the pharmaceutical companies appear to be doing with respect to the Orange Book, which is where patents are listed. What's happening is that one can try to stretch out a patent. You can have a capsule, you can have a drug that's a capsule, and then that's one patent. The next patent is a time-release formula. The next patent is a child-proof container. The next patent, I'm being slightly facetious, but that actually can be a patent. And so what we're finding here is that there are new and ingenious methods being developed to string out patents. In the meantime, pressure continues to build in Congress in this whole area because of the enormous cost of drugs, particularly to seniors. I mean, one of the issues is, for example, Medicare does not pay for drugs, which is good for the pharmaceutical companies in one way, because the federal government has not really been paying that close attention to the cost of these drugs, as Medicare is not putting the bill, the individual seniors are. But one of the things that's happening around the country in terms of Medicaid is that states, because of the budget crunch, are cutting out various drugs from Medicaid formularies. And so poor seniors on Medicaid, or poor people, period, are bearing additional burdens there. So the whole drug situation, the prescription drug cost, is coming to a head, and I do predict that in the next 2 to 3 years we're going to see there's a lot of legislation that's been filed already in Congress to do something about the patents, and I think we're going to see some action over the next couple of years. I think another area that we may see some action in is the predatory lending area, and you've seen some ripples of it. You've seen it mentioned in some lawsuits around the country, and that is trying to hold the mainstream banks or the brokerage houses who are securitizing the predatory mortgages responsible for the acts of the mortgage lenders. Many times when you go after the mortgage lenders, there's not a lot left in the till to pay restitution to consumers. Companies file for bankruptcy, or the lavish spending habits of the owners have depleted the resources, and consumers are left over the bag with not sufficient restitution. And I know that among state attorneys general, this whole issue of going after mainstream banks who provide operating lines of credit to unscrupulous mortgage lenders, or to the Merrill Lynch's or other brokerage houses who are buying the mortgage, securitizing them, and selling them on the bond market, that there is a move afoot nationally in a variety of states to hold these entities responsible. It won't happen overnight. But I think that given what's happened in the economy, we will see an increase in bankruptcies, personal bankruptcies again. We'll see an increase in foreclosures. And when that happens, you'll see pressure building to hold parties responsible. So those are two predictions I didn't get from Ms. Cleo, but I'm going to go out on a limb and make. Now, what is the FTC doing in terms of hot issues right now that are important to consumers? And I do want to spend most of my time talking about privacy issues. If we look over the past 2 to 3 years, there's been a lot happening in this area in a very short period of time. When I first came to town, the big thing was DoubleClick and Abacus, and the prospect of merging online and offline data. Well, that got resolved. Then the next issue, big legal issue around a company called ToySmart out of Massachusetts that was going to sell personal information, confidential information that had been collected under the guise of never doing that sort of thing, promising consumers they were never going to sell the information. They went into bankruptcy, they tried to sell it, a bunch of states and the FTC entered the fray, and that did not happen. At the same time, the Children's Online Privacy Protection Act became effective, Graham-Leach-Bliley became effective, rules designed to protect confidential medical information became effective. During the same period, one FTC administration did recommend broad legislation, while the successor administration at the Federal Trade Commission, rather than recommend broad legislation, is vigorously enforcing existing laws and proposing new rulemakings in the area of privacy. So in a mere, I think, 30 months, there's been a lot that has happened in this area. And I think it's fair to ask a few questions. One, are consumers more protected today than they were simply 3 years ago? And I think in terms of regulatory and statutory regimes, the answer is probably yes. The next question I think that's fair to ask is, what about the business community? Is there greater self-regulation now than there was 3 years ago? And the most recent study that we have that tries to give an answer to that was released just recently by the Progress and Freedom Foundation, which did a study that mirrored the methodology of the Federal Trade Commission studies that were done in the year year 2000 of the 100 busiest websites and so on, just to measure what was going on there in terms of privacy notices and the collecting of information. And that study indicates that progress has been made. Something like 48% of websites now allow third-party cookies. That's down from 78% in the year 2000. This study, by the way, that I'm just talking about, collected information as of December 2001, after September 11th, and so the results are really interesting. I said that's progress, the decline in the number of websites using third-party cookies. Not everyone will agree with it, that is progress, but at least in terms of preserving confidentiality of consumers, we think it is. But I think the last question you have to ask about what's going on in privacy is, do consumers feel that their personal information is more secure? Do they feel more confident about shopping online or shopping anywhere? And I'm not sure what the answer is to that. The last studies I saw were maybe 8 or 9 months ago, which at that time showed that there was still an overwhelming concern, 9 out of 10 consumers claiming that they're very concerned about privacy, and that privacy was the primary reason why consumers did not shop online. And so there were, real serious ramifications of concerns about privacy. I haven't seen recent studies, and I don't know, even though we have these new statutory regimes, Gramm-Lynch-Wiley, we're all trying to figure out whether it works, whether it doesn't work, what those notices really say. Anybody here know what they say? COPPA, we continue to enforce it with references from KRU, referrals from KRU on a steady basis. But again, the statutory frameworks are there. What do consumers really, do they know when they're there? Do they feel safer? And one prediction I will make is that if the answer to that question is not yes, then there's going to be more call for legislation in the future. It is going to become a problematic thing, because it's also the thing that holds up even more growth on the internet in terms of commerce than we've already seen. So there's a direct correlation here between being concerned about privacy and whether people are going to spend money online. And that's one of the reasons it's going to receive attention. The other reason it's going to receive attention at the national level is if states begin or continue enacting privacy legislation and we end up with a patchwork of a quilt around the country in terms of different kinds of privacy legislation. And Chairman Tim Uris of the FTC has indicated that there's one caveat that he held out in terms of his declining to recommend a legislation at this time, and that is if we end up with a patchwork of state legislation across the country that's different, that creates serious problems in terms of the flow of commerce and consumer confusion as well. One of the things that the FTC has just done now in the privacy arena doesn't have anything to do with the internet, nor high technology. It has something to do with the telephone. Not exactly high tech, something that's been around for what, 100 years or more, but still a vehicle that is used by unscrupulous telemarketers to continue with the economic and financial exploitation of consumers, or that's at the worst and at the very least a constant annoyance when one is trying to have dinner or sleep or think and your telephone is ringing. Now, what the FTC has done is to propose very recently the creation of a national do not call registry. Now I know there's one, New York State has one, 20 states have do not call registries, but we're proposing as an amendment to, as a rulemaking to the telemarketing sales rule, a national do not call registry. And the comment period for this proposal has been extended to Monday, tax day. So after you finish filing your taxes, if you're in a mood and you have not filed your comments yet, please, we certainly welcome them. I mean, the view of the FTC in terms of proposing this was simply this. After 5 years of experience with the existing telemarketing sales rule, there's an enormous amount of frustration on the part of consumers with respect to unwanted, unsolicited telephone calls, that the state-by-state approach, and the sort of each company gets one bite at the apple of the consumer approach was something that needed revisiting. So this is what we have proposed. Now, in addition to the registry, there are a couple of other parts of this proposal that we deem major changes to the telemarketing sales rule. One of them is to prohibit telemarketers from acquiring a consumer's credit card number or other account information from anyone but the consumer. This is called pre-acquired account information. If you ever wonder how come you get billed for something that you never ordered, how come it appears on your credit card when you never ordered a particular magazine or piece of exercise equipment, it is because your credit card number was sold to a telemarketer. And you probably received something in the mail that you never even noticed. It was probably a negative option type thing. You threw it out with the rest of the junk mail, and the next thing you knew, on your American Express or your Visa card bill, there it was for $29.95. And right now, that is permitted under the law. And the change that we are proposing would prohibit that, so that your credit card numbers could not, or none of our credit card numbers could be sold or acquired without our permission. A second important item in the amendments to the telemarketing sales rule is that it would prohibit telemarketers from blocking or otherwise subverting caller ID systems, consumers' caller ID systems. There are a number of other changes. They're all important, and some of them deal with requiring various disclosures on the part of telemarketers. But it is a major rulemaking, the first one in terms of amending the telemarketing sales rule in a long time, and the comment period will extends until Monday. There is one more change I do want to mention because it involves charities. Another proposal in the rule actually follows the mandates of the USA Patriot Act. And under the USA Patriot Act, the telemarketing sales rule covers telemarketers on behalf of charitable organizations. It means that telefunders, as they're sometimes called, or telemarketers calling for a charity, have to disclose their identity as well as the identity of the charity and the purpose of the call. The FTC is the implementing agency, and we are proposing rules to do that. Now, this particular proposal has generated a great deal of heat in the charitable and the nonprofit community. There's a great deal of angst as to whether the FTC is planning to regulate charities. Is this a slippery slope toward weakening First Amendment protections around charitable solicitations? Is it the end of the free world as we know it? The FTC is telling telefunders over charities what to do, and the answer to all those questions is, of course, no. This is mandated by the USA Patriot legislation, and it doesn't mean that charities are covered. If charities do the soliciting themselves, they are not covered. If they hire telefunders, for-profit telefunders, then it's a level playing field. You know, it's fair game, treating all businesses alike in that regard. I don't want to use up really much more time, except to mention that in terms of enforcement in the privacy area, the FTC is enforcing the pretexting provisions of Gramm-Leach-Bliley. You know what pretexting is? That's where people acquire the personal financial information of other consumers under false pretenses. And we just settled 3 cases against information brokers who advertised on the web that they could get you anything you wanted to know about anybody, basically. Your charge account, your credit information, bank account numbers, mutual fund accounts, location of safety deposit boxes. We went undercover. We had investigators posing, calling the company and indicating that in one case a female FTC investigator wanted information about her fiance's bank account. And she gave just a little bit of information to the information broker, and lo and behold, she got back a whole lot of information when the broker called the bank pretending to be the fiance and getting that information. So that the area of pretexting is one that we are pretty high on. And the last area that I want to mention in terms of a prediction too is spam. Spam is The FTC, deceptive spam is a very important priority of the Bureau of Consumer Protection at the FTC. And we recently brought a bunch of cases against pyramid schemes responsible for thousands and thousands and thousands of pieces, probably millions of pieces of deceptive spam email. It is an area that Howard Deals is very high on, as is Tim Uris, deceptive spam. Now, the spam issue itself is broader than just deceptive spam. And there are a lot of bills in Congress right now dealing with spam. And I think you're going to see pressure mount in this area. A lot of people feel it's not just like junk mail that you get and throw away, that it's much more intrusive, annoying, it takes your time, you're paying an information service provider to go online, and you have to spend 10 minutes getting rid of all this crappy spam that you didn't ask for, you don't want, you never want to see again, and some of it's pornographic, much of it is annoying, and much of it is deceptive. Our focus right now is on the deception. But it is a growing problem, and unless there's some self-discipline out there, it's one of these things where we may end up with Congress taking action in the area. And they were practically ready to do that before September 11th because pressure had built so much. And I think you're going to see a return of that pressure because the spam is just not abating. Okay, well, I think those are my comments, and thanks for your attention.